This video is a short and simple overview of the history of gender and the law in Australia, touching and highlighting on a couple of important issues. So obviously before 1788 there were many different First Nations groups, many nations, many peoples, many languages, and of course many social and legal groups. And it's estimated there are at least 1,600 plus languages, which correlates to basically 1,600 plus ish nations. Not every nation spoke a different language to its neighbours, and not every nation spoke only one language. However, as you can see, that means a lot of legal systems. And of course, many of our First Nations people did not have written down laws in the same way that Europeans did at the time, but nevertheless they understood their laws and how they were to apply. Across those approximately 1,600 plus nations and groups, there are a whole range of approaches to gender. There were multiple conceptions of roles and genders and recognitions of different numbers of genders, including in the Tiwi Islands, what today are referred to as sister girls and brother boys. That is effectively something similar to what we refer to as trans people in our Western culture. So the customs and laws in relation to marriage, in relation to gender roles, and in relation to sexuality were enormously diverse. There were nations who were reportedly very heteronormative. There were other nations who were reportedly accepting of a range of what we would now consider to be queer sexual practices. There were also, as I said, a range of approaches to gender and gender diversity. In some areas, the law and responsibilities of people was broken down along binary gender lines, such that what we call today women's business and men's business signaled differing areas of responsibility, legal commitments and roles based on sex or gender. And so I don't propose to go into all of these in detail, because as you can see there are many, and I doubt I would do justice in a short video to the many, many different approaches that our First Nations people had. After Europeans invaded Australia, in the convict era and colonial era, there were more impositions of European conceptions of gender across the country. The Europeans came to Australia with very fixed ideas about having a binary gender system, and that people very much had fixed roles within that gender system, which limited the occupations which were suitable to them, the leisure activities, their clothing choices, etc. If you think of people in colonial era Australia in the Regency and then through into Victorian times, you would of course think of women in long dresses and men in trousers, long shirts or suits, very much with a dichotomy of dress styles, very much with limits on what women could do in society as well as what men could do. They were usually limited in their interactions with their household and children, and women were usually heavily limited in their interactions with the world outside the household. The historian Anne Summer, in her book with a similar title, said that European women were divided into effectively two sets of roles: damned whores and God's police. The damned whores were usually convict women. There may be also some working class women. They were usually seen as the object of sexual activity. Whether or not they were actually sex workers, they were seen as available for sex work. Many were imposed on by employers and others and forced to engage in unwanted activity. They were seen as lawless, slatterly, drunken, etc. On the other hand, many free women, particularly women who were middle class or upper class, were seen as so-called God's police. That is, as a civilizing influence on the men of the colony, in whose presence and whose influence should create greater civility, politeness, morality, etc. Men at the same time were seen as prone to drinking, whoring, etc., other than some of the upper class men. And the presence of women was seen and considered to actually reduce that. And at times there were push for free women to come to Australia for that reason. At the same time, our First Peoples did not have, as you know, an easy or happy arrangements with the Europeans. Many were killed. Many women from our First People were trafficked among European men, and sometimes European women who would traffic them as servants or slaves. Pacific Islander women were also trafficked, particularly in North Queensland under the blackbirding system. That was a quasi-slavery, but not legally slavery system, where people from the Pacific Islands were enticed to come to Australia, often to work on cane farms, sugar cane farms that is, and with the promise of wages and work, but who would then find that the living quarters, etc., where they were forced to live, would charge them more than their wages, and so they effectively became slaves. They were trafficked between some farms. The women were trafficked as part of sex trafficking at times, and they would be beaten, whipped, etc. if they stepped out of line. So it was effectively slavery, but without the legal status of slavery. Women who were non-white often had a particularly difficult time under the power of some European men. Another thing to note is Australia's history has always had a range of LGBTQ people. There were different cultural conceptions, as I mentioned, under our First Nations, but even the colonial Europeans, while they may deny the existence of LGBT people, had to be aware that there were LGBT people in their community. Part of this came from the fact that some of the people who were transported to Australia were transported for morality offences relating to gay sex. Until the mid-1800s, gay sex in England was punishable by death, and the attempt by substantial penalties of imprisonment. And in some cases, these sentences were commuted to transportation. If you want to know more about gay culture in England in the 17 and 1800s, have a look at, and just Google, it's quite easy to find, so-called molly culture. The molly culture was basically a gay bar scene. Molly houses were bars often, or pubs, though they could also be coffee houses, sometimes apartment blocks, where gay men would gather. Many of these had private rooms for the use of people who wanted to have sex, but they were also places where gay culture and what we today would probably call trans culture flourished. Cross-dressing was common, so-called weddings, some of which were basically beddings, but some of which were seen as commitment ceremonies, some of which were just for a night, some of which were for life. Depends on the time, the culture, the bar, etc. And many of the people involved would do a range of gender-bending activities. And as I said, cross-dressing was quite common. At this time, there were raids on these places for a long period of time, from the mid-1700s to the relatively late 1800s. If you want to look them up, have a look at Google Mother Clapp's Molly House. There's a book on it actually, and it was one of the first famous raids in the mid-1700s. Men were often arrested in these places. There were men who were killed as a result, for example, of the raid on Mother Claps, but many of the times they were charged with conspiracy or attempt offences if they weren't caught in the act, as it were. And as I said, some of these men were transported to Australia. So it was known, based on their offences, that some of these indecency offences were about engaging in consensual gay sex or being at places where consensual gay sex was common. There are even records on Norfolk Island Penal Colony, which actually show that there were some recognised gay couples who were housed together, and some notes indicate that one was recognised as taking a more feminine role, so may in fact have been a trans woman, though that conception was not in existence at the time. At the same time, there were also women who, often called passing women, who took on male roles in the new colony. Many of these women did so that they could access occupations which were barred to women, though some must have been trans guys, and others may have been butch women who identified as women but preferred a more masculine presentation. And there are a number of accounts of so-called passing women in colonial times in Australia. Throughout the colonial times and really into the quite late 20th century, LGBTQ activities were acknowledged through their criminalisation. That is, it was illegal to engage in a range of same-sex activities. More often this what led to criminalisation of gay men, depending on the wording of the statute, but some were capable of covering women as well. The criminalisation of gay sexual activities was only lifted in Queensland in the 1990s, and many other states, including Tasmania, criminalised gay sex until the late 20th century. In addition to this, there's been no recognition of non-heterosexual marriage in Australia until 2017. That, of course, changed after the recent plebiscite and changes to the law. And there was some recognition of trans heterosexual marriages where the trans partner took a definitive binary expression of their gender, which was opposite to the binary gender of their partner. Thus, in Re Kevin, a trans guy could marry his cis female wife because they fit the definition of one man and one woman at the time of marriage. If you read the case, there's a lot of inquiry into Kevin's masculinity. That is, a lot of commentary about his having a beard, wearing masculine clothing, being assumed to be a man by his co-workers, fixing sinks for his mother-in-law, etc. And so there was definitely some very heteronormative binary discourse in that case. Having said that, though, a trans person who did not have a clear binary identity would not have been able to marry, and neither would an intersex person in Australia up until the recognition of non-heterosexual marriage in 2017. Another area where the law made differences around gender was on property ownership. In the new Australian colonies, women could, like women in England, could not own property once they were married. Technically, the law of coverture said that the husband and wife who were married were one legal person. Effectively, however, this meant that the wife lost her legal personhood and the husband gained control and ownership of all of the wife's property, whether she acquired it before or after her marriage, all of her income, and all of her legal rights. Married women only were able to own their own property in Australia from the end of the 1800s, with the passage of Married Women's Property Acts, which reflected a similar act in the UK. And these passed in various Australian states between 1883 and 1893. However, this did not mean that women were fully free to contract in Australia. And many banks and contracting entities would require evidence of permission by a married woman's husband or guarantees by the married woman's husband before allowing her to enter into transactions. This only stopped with the passage of the Sex Discrimination Act in 1984. There were also sexual and gender differences in the making of income and types of labour that individuals can engage in. Until the 20th century, and in some cases until the mid to late 20th century, women were banned or discouraged from a range of professions and occupations, either legally, as in the various cases that prevented women from becoming lawyers until the early 20th century, or by the industries that refused to hire them. And it was legal until, as I say, the Sex Discrimination Act was passed. Women were often constructed as dependents rather than as people able to work in censuses. So in census data, you'd often see a man listed and then his wife and children listed as his dependents. The man would have his occupation noted in the census, but the woman would be noted often as merely the wife of that man, whether or not she also worked on their farm, in their shop, or at an independent occupation. Of course, our First Nations people were not even counted in censuses at all until the 1960s. There were bans on women continuing work after marriage or pregnancy, sometimes legal bans in earlier times, and certainly industry-wide arrangements where it was perfectly legal to lay off a woman, that is to fire her, once she either married or became pregnant. And as an example of this, my own mother was fired when she got pregnant with me in the 1970s. Yeah, I'm really old. And it was perfectly legal to do so. And she was, of course, not allowed to return to work in her occupation as a telephonist. Until the passage of the Sex Discrimination Act, it was not only legal but often mandatory under various industry awards to pay a woman less than men. And under many awards, women may be paid as little as half to 2/3 of what their male peers earned for exactly the same jobs. Even today, there is a pay gap between men and women. And you may have heard debate about this, but the Australian government itself both acknowledges and collects data on this pay gap. You'll see the link that I've put here. There's also a link to it from the Learning at Griffith site. The current gender pay gap, as at the time I make this video, is 13.9%. However, you may see that there are some interesting things to note about this. Some people say, oh, but women work part-time. That is the full-time pay gap. Women who work part-time and men who work part-time are not counted in this statistic. It is full-time workers only. It is based on the median income of full-time working men in Australia and full-time working women in Australia. You take the average median income of women off of the average median income of men and then express that difference as a percentage of the male income. It's actually a higher percentage if you were to treat women's income as the normative comparator, because we treat the men's income as the basis of comparison. It's actually only 13.9. Another thing to note is if, and as one of the readings say, if you calculate all of the incomes, including part-time and full-time workers in Australia, and women are more likely to work full-time, and express it as a percentage of women's or all women's income in Australia, you come up with a much higher figure, which indicates a bigger disparity in income and a much more precarious situation for some women. Basically, if you take all men's income, including full and part-time in 2019, the average man earns $1,497.40. If you take the average woman's income in 2019, all including full and part-time workers, you reach an income of $1,029.60 per week. This leaves a difference of $469.80 between the average full and part-time men's and women's income. If you express that as a percentage of women's income, so what percentage of $1,027.60 is $469.80, you then have a gap between men's income and women's income of 45.72% if you take overall full and part-time incomes and express it as a percentage of women's income as normative. So in that situation, men earn, on average, 45.72% more than women. So people who say the gender pay gap doesn't exist because of part-time work, etc., are looking at a different set of figures. They're looking only at full-time figures. And if you go to that website, you'll see that there are a couple of reasons for the 13.9% difference, even for full-time workers expressed as a percentage of men's income. And they are based in part on the differential income of men and women in a range of industries. So, just realised I was in the dark a bit. In that many female-dominated caring-based industries such as teaching and nursing have historically and still do earn substantially less than men's income in industries which require a similar level of tertiary learning and physical activities. In addition to that, if you look at those statistics, you'll see that within some areas of industry and professions, there is still a substantial gap, partially because some of the more dangerous jobs that have higher loadings may be done by men, sometimes because of a history of harassment of women who attempt to do them, not always so, and that as in law, there is still a substantial difference at the top end of law firms in that more men are partners in larger firms on average than women. And you can look at the statistics for that on the Queensland Law Society website as well. So have a look at that and you'll see the gaps within certain industries as well as between industries that lead to the 13.9% pay gap. In addition to that, of course, I have to acknowledge that pay gaps also vary on race and sexual orientation. That is, that people of colour generally earn less than white people, with women of colour earning substantially less than white women, men of colour earning less than white men, and people who are queer generally earn less than comparators who are not queer. Though interestingly, the impact is greater on gay men than lesbian women. So the pay gaps are very dependent on a whole range of oppressions. Another area where the law imposed differences was on voting rights. And again, there are both racial and gender differences on voting rights in Australia. So for Australia, the first voting rights were in New South Wales, which gave, in 1842, certain limited classes of men who owned land with particular values voting rights in municipal elections, and then eventually in state elections. All men were given suffrage without property requirements, first in South Australia, where all men over 21 were given voting rights in 1856 without having to prove the value of their assets. South Australia was also ahead of its class with giving women voting rights in 1894. The Commonwealth originally allowed voting rights as per individual states, which meant that in most cases, Indigenous people did not gain voting rights. And in addition, women did not have voting rights in most states other than South Australia. Aboriginal and Torres Strait Island people only had voting rights to the extent that they were already enrolled in a state before 1902 for Commonwealth elections. This allowed some people enrolled in South Australia who were Indigenous, but the majority of states did not allow Indigenous voting. All non-Indigenous men and women in Australia were granted voting rights equally in 1902. So in our first Commonwealth elections, women were actually barred from voting in a range of states, but after 1902, all non-Indigenous men and women who were Australian citizens could vote. Voting became compulsory for non-Indigenous people in 1924. And you may know that we're one of the few countries in the world that actually does have compulsory voting. When were women able to vote at the state level? You can see the list there: New South Wales 1901, Tasmania 1903, Queensland not until 1905, and Victoria was the last state in 1908. An interesting case was Ex parte Ogden, which in 1893 actually looked at the voting rights of married women in New South Wales. This was, of course, overruled in 1901 with the change to voting rights. But in Ex parte Ogden, which was also considered one of the first so-called persons cases, Ogden had been elected in a local council election. The election was extraordinarily close, and there were only a few votes between Ogden and the runner-up, who challenged the election on the grounds that a number of people, only a handful, who should not have been able to vote had in fact voted. And one of the people challenged was a woman who was married. The Municipalities Act New South Wales of 1867 said that every person who was of full age, that is over 21, and owning property, land, could vote. However, the New South Wales Supreme Court said this did not include married women because they were not persons in the eyes of the law. And without some more specific information from the legislature, it could not have been their intention to allow married women to vote. Remember, I talked about coverture and women effectively losing their separate legal status on marriage. And this was one of those instances. A married woman, even though she could by this time own her own property and was over 21, was not allowed to vote because legally she was not a person. Though, as I say, that changed in New South Wales in 1901. It was a lot longer, though, before Australia's First Peoples gained the right to vote. And some of the effects of voting laws privileged the rights of Indigenous men to vote over Indigenous women. Aboriginal and Torres Strait people were not allowed to vote in early Commonwealth elections unless they were already enrolled in on a state electoral roll before 1902. So effectively, people who were Indigenous who were already enrolled could retain their voting rights. No new Indigenous people could enrol to vote. Those who had voting rights could not pass them to their children or others. And it was a relatively limited list of people who actually had those voting rights. and it was less likely to include women, especially in states where women were not allowed to vote, of course. From 1949, people were allowed to enrol and vote in particular states, or if they had served in defence forces, basically for those particular states allowed Indigenous people the right to vote if they were veterans. This covered some Boer War veterans who, up until that point, they had fought as with the colonial armies in the Boer War in Africa. In World War I, there were very, very few First Australians accepted for service. To be qualified for service and to enlist in the army, they must prove that they had a European parent. A mixed race parent was not sufficient, and a person who was of full Indigenous parentage with no European ancestry, of course, was clearly excluded. Only one woman gained voting rights under this rule, and she was a nurse in the British Army. A handful of men were able to gain voting rights through their service. In World War II, there were more service people who were of First Nations origin. There was not the same limit on having to have a European parent. This included some women who served in the Australian Women's Army Service. However, there was an unfortunate and racist practice of discouraging Indigenous people, and particularly Indigenous women, from enlisting. And they were often served in civil support roles beside their peers who were in the army, but without the status of enlistment. So they gained no voting rights through their service because they were civil workers, not enlisted army personnel. Indigenous people as a whole, no matter their gender, gained voting rights only in 1962. So 60 years after people as non-Indigenous people as a whole in Australia. Queensland only granted voting rights to our first Queenslanders in 1965, and voting was only made compulsory for Indigenous people in 1984. Again, a full 60 years after it was made compulsory for all non-Indigenous people in Australia. So you can see that there's some intersectional stuff going on there that you'll hopefully recall when we do intersectionality later in the course. So that's it for a quick romp through a few historical issues that made differences based on gender. And we'll swing back and look at some issues in more detail in individual modules.